Stanley, from your perspective, what are some of the things that, some of the issues you're seeing, and what kind of advice are you giving?
Well, when people come to our office with a FATCA-related or Officer Voluntary Disclosure Initiative-related problem, the first thing we do is we recommend that they go hire an attorney. And the reason for that is very simple. Anything that we do that's not covered by attorney-client privilege leaves the client at risk. So that we don't actually provide service until such time as we are covered by attorney-client privilege. We know that we have a limited privilege on certain civil matters, but since all of these matters border on potential criminal prosecution, we don't believe that it's in the client's best interest for us to just take on a voluntary disclosure on our own without having counsel involved and working through counsel. Not to say we don't know how to do it, we just think it's not in the client's best interest. We've seen a myriad of situations come in. We're very, very aware of a situation that occurred before FATCA was, or right after FATCA was initiated, that occurred in the Midwest with a gentleman, and it turned out that effectively a bank issued us a suspicious activity report to the U.S. government based on a $500,000 transfer from a legitimate bank account in the United States that was the result of a regular business, very successful one, to a Costa Rican bank account for the purposes of buying real estate. It was outside of the normal profile of that person's business. The bank issued the SAR because of the amount, and there was an IRS audit. And that person got banged with very, very hefty penalties and was sort of in a panic situation until he found proper counsel. We were not able to work in the case, but we do know the attorney, the Costa Rican attorney who worked with him and was able to give us a lot of the fact pattern of the case. This is going to be a common problem. One of the things that people don't realize is the banks are already acting as gatekeepers for the government with respect to international transactions and the movement of money. So if the bank feels that a client is outside of their normal profile, they may issue a report, they may not, they may ask questions, but if they issue the report, there's a good chance there's going to be some kind of a response, especially if more than one is issued or it's of a large enough amount of money. So what we do in our office is we are very, very quick to tell our clients who are now beginning to engage in international transactions, they need to update their profiles with their banks, make sure they notify their banks when they're dealing with international transactions, what they expect the amounts to be and how often, so that the banks can then make decisions as to whether or not they're going to engage in suspicious activity reporting or even let them stay at that bank. We've also seen people asked to leave banks. We in our office represent a large number of well-to-do Haitian American clients, and hundreds of them were recently asked to leave 2 banks in the South Florida region. We helped find them other accounts just simply because they hadn't updated their profiles and the bank had updated its own particular security regimen and decided that they didn't want Haitian American account holders who were fitting the profile of these very wealthy people who have business in Haiti and business in the United States. This could happen to anybody. I think the most important thing is, though, and I will tell this to all of my colleagues who call me from the CPA world, don't do it yourself. Hire an attorney or recommend an attorney is hired. Work through the law, through the attorney, and make sure that your client's fully protected, because you're not. You as a CPA, the moment you file a return, there is no privilege with respect to these matters effectively, and you're not doing your client any favors at all. The other thing we tell our clients when they come to us first is we let them know that it's not advisable to use their prior return preparers to do any of this work, because everything their prior return preparer did that did not allow them to fully fulfill their obligations makes them outside of the ability to work under attorney-client privilege, and they could end up being witnesses against them in particular situations. So this is a very delicate new world we're living in, and I'm very, as as David and I were discussing earlier, we believe that the government at some point is going to do the following. Once they have all the information from the banks, they won't have to necessarily go out and criminally prosecute anybody. They'll be able to use the civil fraud route, which is less costly to the government, and simply start banging people for the civil fraud and the other penalties that are involved with unreported income. And they'll be able to do it through notice. So it's going to change the way the world operates, and that's how we're viewing it.